Trump Tower, 40 Wall Street, the properties that aren't just real estate holdings but identity itself, the physical manifestation of a brand built over 5 decades of deals and leverage, and the relentless projection of wealth so total and so permanent that questioning it felt almost beside the point. Judge Arthur Engoron looked at all of it, looked at the buildings and the valuations and the decades of financial statements and the pattern that ran through every document his team spent years examining. And he reached a conclusion that the legal world is still processing this morning because the scope of it, the sheer structural audacity of what he ordered, goes further than anyone predicted, even among the people who were certain Trump would lose. He didn't just penalize the empire. He ordered the dismantling of the machinery that holds it together. And here's what that actually means for the buildings, for the name, for the man who built everything on the idea that consequence was something that happened to other people. Let's start with what people are getting wrong. Because in the hours since Engoron's ruling landed, the coverage has split in 2 directions that are both incomplete. One side is treating this as the total immediate collapse of Trump's real estate empire. Buildings being physically seized today, gold letters ripped from facades this afternoon, the whole structure gone by the weekend. The other side is treating it as a legal technicality, a ruling that sounds dramatic but will be appealed into irrelevance, another chapter in a legal saga that never quite reaches the conclusion it promises. Both of those readings are wrong. And the truth between them is more consequential than either extreme suggests. What Engoron ordered is not immediate physical seizure. What he ordered is the dissolution of the corporate entities that control the properties, the LLCs, the holding companies, the layered legal structures that Trump's organization built over decades specifically to create distance between assets and accountability. Those structures, the ones that lawyers and accountants spent years constructing with careful attention to exactly this kind of legal exposure, Engoron looked at them and said they were built on fraud and therefore cannot stand. When you dissolve the corporate entities that hold a property, the property doesn't disappear, but control of it does. And control in real estate of this value in a portfolio this complex is everything. It's the difference between Donald Trump making decisions about Trump Tower and a court-appointed receiver making those decisions instead. Between the Trump organization negotiating leases and managing revenues and an independent administrator doing it under judicial supervision, between a brand that commands premium pricing because of who owns it and a portfolio in legal limbo because ownership itself is now contested. That's what was ordered. And that's why the people who are saying this is not a big deal are as wrong as the people who are saying the buildings are gone tomorrow. The buildings are not gone tomorrow. But the grip on them just got loosened in a way that has never happened to Donald Trump in 5 decades of real estate. And the loosening, if it holds through appeal, leads somewhere that the gold letters on the facade cannot survive. Let's go back further, because Engoron's ruling didn't emerge from a single trial or a single set of findings. It is the culmination of something that started decades ago and took this specific legal mechanism to finally make visible. The fundamental architecture of Trump's real estate empire was always leveraged on perception, not just the properties themselves. The perception of what the properties were worth, what the name attached to them commanded, what the man behind the name could compel banks and investors and business partners to believe was real when the underlying numbers suggested something considerably different. For 4 decades, that architecture held. Not because nobody noticed the discrepancies. People noticed, accountants noticed, bank examiners noticed, real estate professionals who understood what properties actually traded for in the markets Trump operated in noticed. But noticing and acting on what you noticed were separated by a gap that Trump's lawyers and Trump's fame and Trump's aggressive legal posture kept wide enough to be functionally impassable. You could see the numbers didn't add up. But seeing and proving in a court with consequences was a different thing entirely. And for 4 decades, nobody with the institutional authority and the political will to close that gap actually did it. Letitia James did it, and the story of how she did it, the years of building that case, the methodical accumulation of evidence that eventually produced a 400-page ruling, that story is the context without which Engoron's order doesn't make full sense. She started publicly in 2019 after Michael Cohen's congressional testimony opened a window that her office immediately began climbing through. Cohen didn't just accuse, he documented. He showed the gap between what Trump told banks and what Trump told tax authorities. He demonstrated, with paper in his hands and a committee watching on national television, that the same properties carried dramatically different values depending on who was asking and what the answer needed to be. That testimony was the beginning of the public thread. But investigations don't start with congressional testimony. They start before that, in the quiet accumulation of documentation that makes testimony credible. James's office had been looking before Cohen sat down in that hearing room. They had been examining, And what they found in the years of examination that followed was a pattern so consistent and so documented that the eventual legal action wasn't a question of if, but of when and how. The when turned out to be now. The how turned out to be more sweeping than even optimistic predictions suggested. Because here's what the ruling actually says beneath the legal language. Beneath the findings of persistent fraud, beneath the specific dollar amounts and property valuations, and the meticulous documentation of the gap between what was claimed and what was real, beneath all of that is a simpler statement. You built this on lies, and we can prove it with your own documents. That's what makes this case different from every previous legal challenge Trump has faced. Not the severity of the findings, though the severity is historic. Not the scale of the penalty, though $355 million plus interest is a number that strains the liquid resources of even genuinely wealthy defendants. What makes this different is the evidentiary foundation, his own financial statements, his own accounting representations, his own signature on documents that said one thing to the people lending him money and a very different thing to the people assessing his taxes. You cannot call that a witch hunt and make the accusation stick when the prosecution's primary exhibits are documents you created yourself. You cannot claim political persecution when the evidence of the fraud is evidence you personally generated. The paper trail leads back to one source, and that source has a name that appears in gold letters on buildings across Manhattan. Let's talk about the specific properties, because each one tells a version of the same story, and understanding the individual frauds helps you understand why the collective finding is as damning as it is. Trump Tower first. Because Trump Tower is the original, the building that made the name mean something in the lexicon of American wealth and ambition. The address that became shorthand for a certain kind of success, gold-plated and impossible to ignore and marketed relentlessly as the pinnacle of what New York real estate could mean. Trump's financial statements valued his triplex apartment in Trump Tower at $327 million. $327 million for a single apartment, even one at the top of one of the most famous buildings in Manhattan. To justify that number, the financial statements listed the apartment's size as approximately 30,000 square feet. It is 11,000 square feet. The discrepancy isn't a rounding error or a measurement methodology dispute. 19,000 square feet of non-existent space were added to a document submitted to financial institutions that made lending decisions based on that document. Engoron's ruling addressed this with language that was direct to the point of being blunt. The court found that Trump had simply inflated the size of his own apartment by a factor of nearly 3, creating a valuation that had no relationship to physical reality, and then used that valuation to represent his financial position to parties who had every reason to trust that a man of Trump's stature wouldn't lie about the size of his own home. He did, and the documentation proves it. Mar-a-Lago next, the crown jewel of his post-presidency life, the property that became his primary residence, his political headquarters, the venue for meetings with foreign dignitaries and major donors and anyone who wanted access to the most politically influential private club in American history. Trump's financial statements valued Mar-a-Lago at over $700 million. $700 million for a property in Palm Beach that the county, using standard assessment methodology, valued at $18 million. The gap between $18 million and $700 million is not explainable by aggressive accounting or optimistic market projections. It's explainable by something much simpler. Trump's valuation was calculated as if Mar-a-Lago were a private residence that could be subdivided and developed into luxury homes. Mar-a-Lago is legally deed-restricted as a social club. It cannot be subdivided, it cannot be developed. Its legal status dramatically limits what it can be sold for and to whom. And Trump's own financial team, the people who prepared these statements, absolutely understood that restriction. It's not obscure information, it's in the deed, it's in the county records, it's in documents they had access to. They valued it as if those restrictions didn't exist. They knew those restrictions existed. Engoron found that this wasn't aggressive accounting, this was fraud, documented, provable, conducted with full knowledge of the facts that were being misrepresented. Then 40 Wall Street, the historic building in Manhattan's financial district that Trump acquired in the 1990s and has prominently featured in his portfolio ever since. The financial statements valued it in ways that Engoron found were similarly disconnected from market reality, similarly constructed to present a picture of wealth that served Trump's purposes with lenders and business partners, while bearing limited relationship to what independent appraisers and market participants would recognize as the building's actual value. Property by property, building by building, Engoron's ruling documents the same pattern. Not mistakes, not aggressive, but defensible accounting interpretations. A systematic practice of presenting values that served whatever purpose Trump needed them to serve at a given moment, regardless of their relationship to reality. Persistent fraud. That's the finding. And that finding is the foundation for everything that comes after it. Let's talk about the dissolution order specifically. because that's the piece that has real estate attorneys across the country staring at the ruling and trying to understand its full implications. When a judge orders the dissolution of corporate entities that hold real estate, the properties themselves don't automatically transfer ownership. What happens is more complicated and more consequential than a simple transfer. The entities that legally own the properties cease to exist in their current form. The assets they held must be distributed, liquidated, or transferred through a process supervised by the court. And during that process, control sits not with the original owner, but with whoever the court appoints to manage it. Engoron appointed an independent monitor with sweeping authority over Trump Organization operations. Every major financial decision, every significant transaction, every material change in how the properties are managed or positioned, all of it now requires the monitor's review, and in many cases, the monitor's approval. What that means in practice is that Donald Trump cannot make unilateral decisions about his own buildings. He cannot sell them without court involvement. He cannot refinance them without court involvement. He cannot restructure the entities that hold them without court involvement. The brand that operates from those buildings, the Trump Organization that negotiates leases and manages properties and licenses the Trump name to developments worldwide, that organization now has a supervisor that it didn't choose and cannot remove. That supervisor answers to Engoron, and Engoron found persistent fraud. The practical implications compound quickly. Tenants in Trump properties, commercial tenants who signed leases based on representations about ownership stability and management continuity, are now operating in buildings whose legal status is contested and whose ownership structure is in the process of being dismantled. Some of those tenants have already begun making inquiries. Some have already begun exploring whether the changed circumstances give them grounds to renegotiate or exit their agreements. Banks that hold debt on Trump properties are conducting their own assessments. Lending agreements contain provisions about material adverse changes to the borrower's situation, a $355 million civil judgment, a ban on serving as an officer or director of New York corporations, and a court-ordered dissolution of the corporate entities that hold significant collateral all qualify as material adverse changes under virtually any standard. Those banks are looking at their covenants and their options simultaneously. Insurance companies are doing the same thing. The independent monitor's presence changes the risk profile of the properties in ways that actuarial models weren't built to accommodate. Policies will be reviewed, premiums will be reassessed, some coverage may be withdrawn or restructured in ways that create additional complications for properties that are already operating in legal limbo. And the Trump brand itself, the intangible asset that Trump has always argued is worth more than any physical property, is absorbing damage that dollar amounts don't fully capture. The brand's value has always been built on the projection of untouchable success, of a man who wins, who builds, who puts his name on things and makes them more valuable by the association. A court finding of persistent fraud, a judicial order dismantling the corporate structure that holds the empire, a ruling that describes the defendant's financial representations as a fantasy world. All of that is antithetical to the brand's foundational promise. Some of Trump's licensing partners are watching this carefully. Developers who pay to put the Trump name on their projects, who've built marketing campaigns around the association with that name, are now calculating whether the association still commands the premium it once did, or whether it's become a liability that potential buyers price negatively. That calculation, happening in boardrooms and marketing meetings across multiple continents, is ultimately as threatening to Trump's long-term financial position as any specific dollar amount in Engoron's ruling. Here's what the appeal looks like. Because Engoron's ruling is not the end of this. Trump's legal team filed their notice of appeal almost before the ruling's ink was dry. And the appellate process in New York has its own timeline, its own standards of review, its own dynamics that make the outcome genuinely uncertain, even to the most experienced observers. The appellate arguments Trump's team is advancing fall into three broad categories. The constitutionality of Executive Law 6312, the New York statute that allows the Attorney General to pursue fraud claims without proving specific victim damages. The excessiveness of the penalty, $355 million plus interest, representing what the defense argues is a constitutionally disproportionate response to conduct that caused no proven financial harm to any specific party. And the alleged bias of Judge Engoron himself, whose early rulings and courtroom demeanor Trump's team argues demonstrate that the proceeding was not conducted with the impartiality that due process requires. Each of those arguments has some legal merit. Not enough in the view of most independent legal observers to produce a full reversal, but potentially enough to produce modifications that reduce the penalty, limit the scope of the dissolution order, or create procedural grounds for a new trial before a different judge. The appellate court has received briefing. Oral arguments are scheduled. And the judges who will decide the outcome are weighing not just the legal merits, but the institutional implications of whatever they choose. If they uphold Engoron's ruling fully, they establish precedent for the most aggressive use of 6312 in New York legal history. If they significantly reduce it, they risk being seen as having provided a powerful defendant with protection that less famous fraudsters would never receive. Neither outcome is clean. Neither outcome avoids institutional consequence. And the judges deciding it know that whatever they write will be read not just as a ruling in this specific case, but as a statement about what New York's legal system is willing to do when the defendant is the most famous real estate developer in American history. To post the appeal bond, which in New York typically requires posting security for the full judgment amount, Trump needs to come up with something approaching $500 million, accounting for accumulated interest in cash or equivalent collateral. Reports that more than 30 insurance companies declined to provide that bond have been circulating. The reasons vary, but they converge on the same fundamental assessment: the risk profile of guaranteeing an appeal bond for a defendant with multiple simultaneous legal exposures, contested asset valuations, and a documented history of misrepresenting financial information is not a risk that standard insurance markets price easily. If Trump cannot post the bond and the appeal doesn't produce an immediate stay of enforcement, Letitia James's office can begin enforcement proceedings. She has said publicly that her team is prepared to do exactly that. Property evaluators are ready. Legal mechanisms for placing liens on real estate are understood and available. The process for moving from judgment to enforcement is not complicated. It is uncomfortable, politically explosive, and unprecedented in its specific application. But legally, it is straightforward. Trump Tower could have a lien on it while the appeal is pending. 40 Wall Street could be subject to enforcement action. The gold letters on the facade don't protect the building from a judgment that's been entered and not bonded against. Here's what keeps coming up in conversations with people who've spent careers in New York real estate law. The thing that distinguishes this moment from every previous Trump legal challenge. In every previous case, the resolution was always theoretical, always somewhere in the future, past the next appeal, past the next procedural maneuver, past the next delay. The consequences were always conditional on outcomes that hadn't happened yet. This judgment is entered. It exists as a matter of law right now. It has legal effect right now. The enforcement mechanisms are real and available right now. The stay pending appeal, if it's granted, exists only because the court chose to grant it, not because anything about the underlying judgment is uncertain or provisional. That's what's different. The weight of legal consequence that Trump has spent 50 years maneuvering around, that his lawyers have spent decades keeping theoretical, has become actual. It has a dollar amount. It has an enforcement mechanism. It has a judge who found that the defendant's lack of contrition and remorse borders on pathological and who structured his remedy accordingly. For the first time in Trump's business life, the consequences aren't coming. They're here. What happens to the man himself? That's the question underneath every legal analysis and every property valuation and every appellate argument. Because Donald Trump's identity, his self-conception, his entire public persona is so thoroughly wrapped up in those buildings, in those gold letters, in the idea of himself as someone who builds things that last and puts his name on them and makes the name worth more by the association, that a legal ruling dismantling the corporate structures that hold those buildings is not just a financial event, it's an identity event. People who know him well say he doesn't process this the way a standard defendant processes an adverse ruling. The legal arguments, the financial calculations, the appellate strategy, all of that is real, and he engages with it. But underneath that engagement is something more fundamental that the people closest to him have always understood. He believes the name is bigger than any ruling. He believes the brand survives because the brand is him, and he cannot be diminished by an institution he doesn't respect. That belief has served him well for decades. It's the psychological architecture that allows him to walk into rallies while facing multiple criminal indictments and project absolute certainty of ultimate vindication. But belief doesn't bond an appeal. Belief doesn't satisfy a judgment. Belief doesn't prevent a lien from attaching to a building or a receiver from being appointed to manage one. The legal machinery that Engoron set in motion operates on its own logic, and that logic doesn't account for the defendant's belief in his own invincibility. The gold letters on Trump Tower have been there since 1983. They've survived every deal that went bad, every bankruptcy that reshaped his business, every legal challenge that threatened the empire and ultimately didn't reach it. They've become so permanent a feature of the Manhattan skyline that most people who walk past them don't even consciously register them anymore. They're just there, part of the landscape, part of what New York looks like. Judge Engoron looked at the building behind those letters, at the documents that supported the valuations that justified the empire those letters represent. And he found something that the letters were designed to prevent anyone from finding. The foundation underneath the gold. It was sand. Documented, provable, built on decades of misrepresentation that finally encountered a legal mechanism willing and able to say so in writing with consequences. The letters may stay on the building for months. The appeal will take time. The enforcement will be contested at every step. The process will be slower and messier and more legally complicated than the dramatic framing of immediate seizure suggests. But Engoron has said what he found. The record contains his findings. And whatever happens next in the appellate courts, whatever stays are granted or penalties reduced or procedural modifications made, those findings are part of the permanent legal record now. Persistent, egregious, fraud. Written by a judge who spent months watching the evidence accumulate and the defendant dismiss it, who listened to the arguments and read the documents and watched the man on the witness stand argue with the proceedings and deliver campaign speeches from the witness chair, and who decided that the accountability that had been absent for 50 years was now his responsibility to provide. The buildings are still standing, the letters are still up, but the legal ground beneath them shifted in ways that may not be visible from the street and cannot be argued away in any courtroom. Something that was always theoretically possible just became real. And the man whose name is on those buildings woke up this morning in a world where his empire is no longer entirely his to control. Whatever happens next, that is permanent. That is the record. That is what the legal history of this moment will show when people look back at it and try to understand how the most famous name in New York real estate ended up in a courtroom where a judge had enough evidence to say, clearly and in writing, that the foundation was always something different from what the gold letters promised. The next ruling comes soon. The appellate decision is forming. The enforcement clock is running. And somewhere in Manhattan, the gold letters catch the light exactly the way they always have. But the man who put them there is fighting for the first time in his life to keep them where they are. That fight has no guaranteed outcome, but it has a starting point that nothing can change now. Engoron put it in writing. And writing, unlike gold letters on a building, doesn't negotiate,